would like to hear a closing argument from each attorney, and we will then adjourn. At the present time, we take to the hearing officer for a 1-hour adjournment to allow attorneys to organize their final argument. And then when we come back, go into session, we will allow each attorney on each side to give 1 hour for closing arguments, and then this meeting will be adjourned.
One question.
Yes, sir.
Do you expect any report from me based on that then?
Yes, sir. We will make a decision after receiving a report from you, from what you've heard.
Okay. I have an incomplete record in terms of the witnesses that have been scheduled. And I have heard evidence pertaining to only 2 specific violations in the notice of violation letter. I just put that on the record so you understand the findings of fact you're going to get from me, the conclusions of law, and the recommendation are going to be limited to only the record I have before me. Okay? Do you wish me to stay while the closing arguments are made?
Told you.
Sure.
Okay, all right, fine.
I have one matter
Yes, sir,
that I
Mr.
need to raise. I beg the permission of the board to, for me to put Mrs. Ben on as a short witness to authenticate the records. Is that allowed?
Here's what I typically do, and then you tell me if you still want to make that request. I will prepare a certification by the hearing officer of the record that I have received. I have the record in front of me. I have all the original documents. And I will certify to the board that record.
That's sufficient.
Okay.
Thank you.
I would like her to certify the transcript that she prepares at the later stage.
Very good.
And then I will forward that on to the board along with my written report.
That's fine. Thank you.
And for the record, I would certainly object. I mean, we have
Keep
here,
smiling.
my client has a property right and a procedural right that needs protected in this matter. And the board, which I had previously requested that them recuse themselves because of their position as defendants in a federal civil rights action, and also that they're not legally appointed to serve as board members because of their secret ballot status. But to stop the hearing before the license holder has an opportunity to be heard, to bring forth his witnesses, I believe violates my client's due process rights as are set forth in Ohio Revised Code Section 119. I would ask the hearing officer to deny their request to terminate the hearing in midstream, not even midstream, I don't think the stream's a quarter of the way through, and allow the permit holder, Berry Meadows, to proceed with his case so he can defend himself.
I understand your point. I serve the pleasure of the board. The board has made a decision in terms of how they wish to proceed. I will follow that decision. So is it your wishes then that we adjourn for an hour? And then council will be allowed to come back after an hour and make the closing arguments? Mr. Pearson first and Mr. Anger second. Okay, I have 8:35. We are adjourned until 9:35.
Your Honor,
Yes.
if I can. Also, I would be requesting attorney fees for the prevailing party, which I believe would be Berry Meadows in this instance, and would allow the record to remain open so that we can submit final attorney fees that we're allowed to request pursuant
I
to.
think the record remains open until your closing statements. I think that's something that's appropriate in addressing your closing statement.
But I won't have the final tally of my attorney fees and also the costs involved in this action until after the hearing tonight.
I understand.
It would be impossible to
I understand.
know what a full cost is.
Yep.
And that's part of your jurisdiction to rule on my attorney fees as well.
My task here is to make findings of fact, conclusions of law, and the recommendation to the board.
The independent hearing officer pursuant to 119 also has the ability to award attorney fees to the prevailing party if they meet certain statutory definitions, that being less than $1 million net worth, employees at a small business level, and certainly the hearing officer has more than just the ability to find the facts and conclusion of law. If the board has not met its burden of proof, and has failed to sustain that burden, and we are the prevailing party, we are entitled to a determination as to attorney fees in this matter. And I'll be requesting attorney fees.
I understand.
For the record, because if somehow you don't think you can award attorney fees, then that's a matter for appeal. Even if I win or I lose, I still have the right to appeal the request for attorney fees.
Is the board intending to allow Mr. Pearson and Mr. Anger to submit post-hearing briefs before I prepare my final report?
Sure. As far as I'm concerned, sure.
Okay, then in your
I
post.
can't speak for all of the board.
Okay,
It doesn't surprise me. It may I be heard on the issue of attorney fees and post-hearing. I don't have the chapter 119 in front of me. I do not doubt what Mr. Andrews said. I'm sure there is no mandatory duty that you would consider awarding attorney fees. I'm sure that it's within your discretion.
all right, thank you for your
Secondly.
statement. Go ahead.
Secondly, I have a closing statement prepared. I will go ahead and prepare a post-hearing brief as well.
You both have made statements that you view this to be a 119 hearing. I'd like you to brief that, Mr. Anger and Mr. Pearson.
I'm sorry.
You both have made statements that you assume this is a 119 hearing. I'd like you to brief that. I'd like you to focus on 11901A, the definition of administrative agency. Okay?
Yes.
Thank you, I appreciate that, that'll be helpful for me. Deadline for stenographic record. When do you think would be a reasonable time for you to have prepared the record of the hearing? Stenographic record of the hearing.
It's taking the holidays into account, 3 weeks.
I'm asking you, because you know your schedule, we don't, and you let your schedule dictate this.
I would say 3 weeks.
Okay. Today is the 16th, so that would be approximately December 16th.
It's probably going to be December.
December, what, 7th?
I have a calendar.
Oh, I can. I can completely believe it.
Third, 30th,
If you look
would be
at the
December
4th and
7th.
the 11th, sir.
Pearl Harbor Day, December 7th,
Okay.
Friday.
Is that Friday? You want the following Monday? What date is that?
December 10th.
December 10th. The stenographic record will be distributed to the hearing officer, the board, and the parties on December 11th.
Your Honor,
Yes, sir.
I had requested yesterday of the board, and maybe through the council, I would like a response on the record as to my request for them to recuse themselves, because it's certainly, in any event, going to be a matter for of a record, not only in this action, but in the pending action I have in the Court of Common Pleas, to the board itself, not to Dr. Enyeart. But I have requested the board recuse themselves, which is a fundamental procedural issue that I crossed at the beginning of this hearing. But then secondly, beyond that, in having the board actually respond as to, are they denying my request to recuse themselves and not acknowledging the conflict? And then number two, under what authority is the board taking action to terminate this hearing without going forward? I don't know that, so if I could have.
You've made a record on that.
But as the independent hearing officer, and I'm looking at 119, and I don't know what rules that you thought you were working under. It wasn't being appointed properly by this board. But what is the authority for the board to postpone or stop a hearing after it has begun?
Based on what you just said, Mr. Alexander, I don't see a need for me to respond, Mr. Rankin.
Is there a need to?
No, I say I do not see that there is a need.
I don't either. I think these are matters that, while appropriately raised, will obviously not be addressed to the board at this time. We're gonna recess here. That is it's the board's prerogative, not mine.
The recusal.
I understand, and once again, it's the board's prerogative to determine how they're gonna address that, because that's a request to them. And as
Right.
I've said in my earlier ruling, that's outside of my bailiwick.
And I appreciate that, and you said that in your earlier ruling, but to the board president, I've asked for recusal of the board. Is the board denying?
Well, I'm
My request.
gonna interject and say that although he's asking you that question, you directed me now to recess this for an hour, and I'm going to do that. And then you can respond or not, obviously, at your discretion, when you reconvene or some other time. Now, let's talk about timeline for briefs. You're gonna have transcript on the 11th of December. You all have your schedules in hand. You have a notion of what your time constraints are. You tell me how much time you want for briefs.
1 week is fine with me.
I need 30 days, certainly through the holiday and trial schedule.
What is the holiday season?
It is the holiday.
I know.
So December 11th, and that would take it to January 11th, which is a Friday as well.
Briefs are due January 11th. We are recessed for an hour.
Thank you, sir.
Thank you, sir.